All right, hey everyone, Eric Gros-Dubois. We're gonna do a 5-minute video. We're gonna do a deep dive on trademark infringement. So here's a real story. A client of mine has been in business for almost 20 years, and they have a pretty unique name. And, I didn't help them pick their name. They never came to me to talk about their trademarks. And in fact, we now are talking because there's an infringement situation. So they had a customer and they were talking to their customer, and the customer was like, "Oh no, we already did this thing with you." And they was like, "No, you didn't." They were like, "Yes, we did." And sure enough, the customer was dealing with one of their competitors. And it was kind of like shocking to our client. They didn't know about this other company. So now we're digging in, and they're having a meeting with me, and they're like, "Okay, so here's where we start." I'm like, "Okay, so how long have you been in business?" And they can kind of prove their first date in business. And in their case, it's when they created their LLC here in Florida. It's public records. You can go search on sunbiz.org and you can look up the LLC registration. And the name of their LLC is actually the name that they've been doing business under since the beginning. And so that is almost 20 years. So then I go ahead and I search if they've registered a fictitious business name, also known as a DBA here in Florida, or doing business as. And a lot of times, like for example, we have EPGD Attorneys at Law PA. That's the actual name of our entity. But then we have EPGD Business Law. That's one of our DBAs. We have EPGD Trust and Estates. That's one of our business DBAs, one of our fictitious business names. And we have a couple others. And so then level 3 is I actually look and see if there's any Florida trademark registrations, which there aren't. And by the way, in the case of my client, there were no other names of companies that were similar. There were no other trademarks that were similar, but there was a DBA that is similar, and that's the actual competitor that we're talking about. And that one is only 2 years old. So then I look deeper onto the DBA registration, which, by the way, if you're going to do business in a name not your company, so if you have the name of your company with the LLC or the Inc. or the Corp, and then you want to have like a different transactional name, you need to register it. It's really cheap. It's $10 a year here in Florida. And so then that registration will show the owner, and the owner was this other company that has been in business quite a bit longer. So then I go and look up the federal trademark registration. Now, this doesn't always be relevant. It's not always relevant because sometimes your business is just going to be local. Sometimes it might just be statewide. But in this modern day and age, a lot of things we can sell online. And the gold standard for registrations is the federal trademark registration at the USPTO. So I go and I search the USPTO, and sure enough, my client's like, "I don't have that." I'm like, "Well, actually, you do." And he goes, "Really?" And I go and I look through, and the person that registered it was his wife about 5 years ago. And he's like, "Oh, I didn't even know she did that." I'm like, "Yeah, well, she did. That's awesome." So now that gives them access to the federal courts if they ever need to sue someone for trademark infringement, and it gives them attorney's fees, which is really the most important thing. A lot of times, your damages might be a few $1,000s, but it might cost you a whole lot more than that in attorney's fees if you have to sue someone. So if I can say, "Hey, not only can we go after your damages, and maybe we can get even more damages because we have access to federal statute, but we can also get your attorney's fees and costs," that a lot of times will change the equation versus a common law trademark, which is what you just have when you start doing business in the name of whatever you're doing it in. And the best is, in our case, we've got actual real people that will testify under oath that they were confused, that they actually did business with the wrong company because they didn't know which one they were supposed to be doing business with. So the moral of the story is we have first use about 20 years versus 2 years. We've got trademark registration. In his case, it's about 5 years old, even though the registration date, the most important date, is first use, but we still have the 5 years, which I've done other videos where we talk about incontestability, which means once you hit 5 years, your trademark just gets even more powerful. And we've got actual confusion. So in our situation, we're going to start with a demand letter. Hopefully that leads to either the other side changing their branding, or maybe a negotiation, maybe a coexistence agreement, maybe some way that we can divide up the world and decide to live together, or lawsuit. And if we have to end up in federal court suing under the Lanham Act with access to attorney's fees and costs, our client couldn't be in a better position. So if you guys have questions about this, if you want to protect your brand, or you think someone's infringing on your brand, leave a comment or reach out to me and we can go ahead and schedule a meeting. Thanks, guys.